Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath for affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Franklin Cann, Senator the Honorable Dennis Moses, and Senator the Honorable Alison West, all of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Harvey Boris, whereas Senator the Honorable Franklin Cann is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula Mae Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Harvey Boris, to be a member of the Senate temporarily, with effect from the 4th of December 2019, and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Franklin Cann. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, the 2nd day of December 2019. To Mr. Ndale Young, whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula Mae Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be a member of the Senate temporarily, with effect from the 4th of December 2019, and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Dennis Moses. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, the 2nd day of December 2019. To Mr. Wayne A.M. Innes, whereas Senator the Honorable Alison West is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula Mae Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Wayne A.M. Innes, to be a member of the Senate temporarily, with effect from the 4th of December 2019, and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Alison West. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's, this 2nd day of December 2019. Honorable Senators, Senators are required to take the oath.
I, Harvey Boris, having been appointed a member of the Parliament, do hereby swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility of the people of Trinidad and Tobago upon which I am about to enter.
I, Andali Young, having been appointed a member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Wayne Innes, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Acting Leader of Government Business.
Madam President, I have the honor to lay the following papers listed on the order paper in my name. The ministerial response of the Ministry of Agriculture, Land and Fisheries to the 23rd report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of Invest TT for the years 2014 to 2017. Thank you.
Minister of Works and Transport.
Thank you, Madam President. Madam President, I have the honor to lay on the following papers listed on the order paper in my name. The ministerial response of the Ministry of Works and Transport to the 23rd report of the Public Account Enterprise Committee on the examination of the audited financial statement of Invest TT Limited for the year 2014 to 2017. I thank you.
Minister of Trade and Industry.
Thank you. Madam President, I have the honor to lay the following papers listed on the order paper in my name. the ministerial response of the Ministry of Trade and Industry to the 22nd report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of Creative TT for the financial years 2014 and 2015. Thank you.
Acting Leader of Government Business.
Madam President, I have the honor to lay the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Public Administration, the Minister of Planning and Development, and the Minister of National Security and the Honorable Attorney General. The ministerial response of the Ministry of Public Administration on the 23rd report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of Invest TT Limited for the years 2014 to 2017. The ministerial response of the Ministry of Planning and Development to the 23rd report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of Invest TT for the years 2014 to 2017. The ministerial response of the Ministry of National Security to the 12th report of the Joint Select Committee on Human Rights, Equality and Diversity on the sexual exploitation of children in Trinidad and Tobago, with specific focus on child prostitution and child pornography. And the annual report of the Legal Aid and Advisory Authority for fiscal year 2014-2015. I thank you.
Reports from committees.
Acting Leader of Government Business.
Madam President, I have the honor to present the following report as listed in the supplemental order paper in my name. The interim report of the Special Select Committee of the Senate on the Evidence Amendment Bill 2019 in the 5th Session, 11th Parliament. I thank you.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Minister of Energy and Energy Industries. In light of reports of a breakdown in negotiations between Paria Fuel Trading Company and Unipet, resulting in an immediate discontinuation in the supply of fuel to Unipet, can the Minister state how this decision will impact the motoring public?
Minister of Energy and Energy Industry.
It is my pleasure to answer this question as Acting Minister of Energy of the Government of Trinidad and Tobago. I am advised, Madam President, that NP presently has a network of 117 operating service stations which are strategically located throughout the length and breadth of Trinidad and Tobago. Unipet has 24 operating service stations which are primarily located in densely populated areas, also served by NP service stations. I'm further advised that NP has the existing capacity and capability to meet the fuel requirements of the motoring public, and that additional resources have been put in place in terms of the supply and delivery of fuel at NP service stations to deal with any issues that may arise. I can also advise, Madam President, that Paria Fuel Trading, which is the wholesale supplier of motor fuels, and Unipet are currently involved in negotiations, and it is expected that the impasse will be of a short duration, minimizing any disruption to the motoring public.
Senator Mark.
Madam President, can the Minister indicate what are some of the factors or issues that are contributing to this unhealthy situation as it relates to a breakdown in negotiations causing a discontinuation of supply of fuel to Unipet? Can he advise?
Minister.
Firstly, let me correct Senator Mark. There's no breakdown in negotiations. What has happened was, when Paria Fuel Trading was formed last year, there was a short-term written contract put in place with Unipet. That written contract expired in March of this year. Since March, in the months of April, May, June, July, August, September, and October, the arrangement between Paria Fuel Trading and Unipet has been by way of a monthly arrangement, which is executed by a letter on the same terms and conditions as the previous arrangement in terms of credit and so on, which is signed by both sides. Between April and October, Unipet signed the letter and adhered to the credit terms for the supply of fuel, which are, in the first instance, 45 days, then it goes to 55 days, and so on, from the first supply of fuel. In November, Paria sent the usual monthly letter to Unipet for its signature. Unipet declined to sign the letter. Unipet was given fuel in good faith by Paria. Unipet declined to pay for fuel and owed Paria $172 million as of a couple weeks ago. Paria and Unipet met, and Unipet agreed to make a part payment of $68 million. However, it only made a payment of $64 million, and it has still declined to sign any written arrangement with Paria, and it now owes Paria in excess of $100 million for fuel supplied without any written agreement.
Senator Mark.
Madam President, through you, can the minister indicate how soon, given the circumstances outlined by the Honorable Minister, how soon does the minister anticipate or expect a resolution to this very important matter that could eventually and ultimately have an adverse impact on the motoring public?
Minister.
President, let me re-emphasize that this is an issue of non-payment for fuel supplied. It is an issue of non-signatory of an agreement which has been in force for several months. As the Acting Minister of Energy, it is my intention to intervene in this matter to bring some relief. However, we have to ensure that anybody who is supplied with fuel that is paid for by taxpayers' money pays their bills and pays them on time. As I said, NP has the capacity to supply fuel, but I intend to intervene and see if I can get this matter resolved in the shortest possible time, get the parties back together so we can produce a proper agreement between Paria and Unipet going forward without any difficulties.
Next question, Senator Mark.
Thank you, Madam President. To the Minister of Health. Given the recent revelation that there have been 24 deaths over the last 2 months from the influenza virus, can the minister state whether health institutions are being directed to treat with suspected cases of influenza as critical?
Leader of Government Business.
Madam President, the Chief Medical Officer, in accordance with existing protocols, has directed health institutions to treat with suspected cases of influenza as critical. Thank you.
Senator Mark.
Can the Honourable Minister indicate, if that is the case, can the Honourable Minister indicate why we have had thus far 24 deaths in this country?
Senator Mark, I won't allow that question. Next question.
To indicate what comprise the elements that would constitute critical in the context of what he has outlined. What would inform it?
Acting Leader of Government Business.
Madam President, critical actually begins much before the influenza season, as the Ministry of Health refers to it. Every year, prior to the October to May period, all physicians in the Ministry of Health, in fact, and all physicians in the country are resensitized with respect to the management of the influenza. The ministry ensures that all WHO protocols are followed. The ministry ensured in relation to influenza that the required number of vaccinations are in the country and available to the public. Now, in response to a statement made previously by the head of the Pharmacy Association, the Minister of Health indicated that provision is not made for every citizen of this country to be vaccinated. In relation to the influenza, there are particular categories of risks, and these categories include the elderly, those suffering or affected by diabetes, minors, and people in particular vulnerable circumstances, pregnant women and children 6 months to 5 years. So the risk is in that particular, the risk is a particular period of the year, October to May. The risk measures are in place during that period, and prior to that there is some sensitization. The deaths you are seeing is consistent with previous years, and those deaths have been confined to elderly persons and children in that age group 5 months to 6 years, and persons suffering from critical illnesses or debilitating illnesses. There's been no instance in which someone from outside that category has died of this influenza. Thank you.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, there are 3 questions on notice and 1 question for written answer. The government will be answering question number 10, question number 12, and asking for a deferral of question number 11, and the written submission would be made during the course of this sitting. Thank you.
A deferral of 14 days for question number 11.
Madam President.
So question number 11 is deferred for 14 days. Senator Mark.
Just a clarification, Madam President, could you clarify the written one in the appendix question?
Government Business indicated that that will be circulated during the sitting.
Oh, thanks. Okay, thank you very much. Question number 10 to the Prime Minister.
Acting Leader of Government Business.
Madam President, the Tobago House of Assembly has advised that the Studley Park Waste Integrated Facility is currently operated according to industry best practices. This facility has 2 sections, the liquid waste and the solid waste sections. The liquid waste disposal site is well maintained and uses stabilization ponds as a method of liquid waste treatment. These ponds are cleaned annually, and all leachate from the landfill is collected in the first pond. All runoff from the final pond is also treated through a chlorination process and collected via a tank, which is then reused at the solid waste section. The solid waste disposal site uses engineering cells to treat domestic water. The waste is disposed of via these cells and covered every other day or each day if the quantity of material is sufficient. This covering assists with the reduction of flies and pests, as well as reduces the scent at the landfill. Burning of waste, Madam President, does not occur at the landfill. However, due to the high content of methane gas and flammable material, fires may occur from time to time, and this is dealt with by the fire services. I thank you.
Senator Mark.
Madam President, given what the Honourable Minister has outlined, could the Minister indicate why then residents of Mount St. George have been expressing grave concern as it relates to their health arising out of this Studley Park landfill? Why have they been expressing these concerns?
Sir?
Madam President, the THS certainly cannot stop the residents from expressing concerns. But from time to time, there are concerns expressed by the affected communities named by my friend, and these concerns are addressed. And there's also the opportunity for concerns to be reported to the Public Health Department, Public Health inspectors. But as far as possible, the THA has been addressing the issues and taking steps to reduce the risk to the population. But it is impossible to stop people from talking and making complaints which may or may not be true. And as far as possible, the THA addresses these complaints where they are legitimate.
Next question, Senator Mark.
Question number 12 to the Minister of Health.
Acting Leader of Government Business.
Madam President, my colleague Senator Mark would be happy to know that the Cedros Health Center currently offers a 24-hour accident and emergency service. However, serious consideration is being given to making available a full 24-hour service in Cedros. Of course, that comes with the requirements for human and financial resources. The Minister of Health is given active consideration to it and will determine whether he has the financial and human resources to expand the current 24-hour arrangement for accident and emergency to a full health service facility in Cedros. Thank you.
Senator Mark.
Can the Minister give the Senate any possible indication as to a possible period when a decision would be taken, one way or the other, to address the other areas outside of accident and emergency matters?
As I said, the Minister of Health has indicated that he's given active consideration, taking into consideration the availability of both the human and financial resources. And when that exercise is completed, he would make a determination on whether it's something that is feasible, if it's something that could be phased in, if it's something that based on the demand, he can offer particular services beyond accident and emergency over a 24 period. That would be determined based on the availability of resources and the demand for the specific services in Cedros. Thank you.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Mark.
Thank you, Madam President. Madam President, in accordance with Standing Order 16, subsection 2, I hereby seek your leave to move the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance, namely the failure of the government to broker an agreement between Paria Fuel Trading Company Limited, known as the Paria Fuel Company, and Unipet Company Limited. The matter is definite as it pertains specifically to a critical decision taken by the Paria Company to terminate the supply of fuel to Unipet, effective from Tuesday, December the 3rd, 2019. The matter is urgent because Unipet operates several fuel stations and/or service stations that provide a convenient and alternative source of fuel for thousands of motorists, and the potential closure of these stations will impose significant inconvenience to motorists and the wider population. The matter is of public importance since the decision of the Paria Fuel Company will eliminate competition in the fuel retail sector and will therefore create a monopoly. Additionally, Unipet employs hundreds of persons who will all, sadly, be on the breadline as a result of this decision. I thank you for your consideration of this critically important matter, Madam President.
Honourable Senators, I have considered the motion as presented and I am not satisfied that this matter qualifies under this standing order. I just want honorable senators to note that this issue was raised under Standing Order 25 as an urgent question.
Personal explanations.
Senator Obika.
Thank you, Madam President. Madam President, when it comes to my action in question, to all who have been offended, including Madam President, Mr. Vice President, all members of the Senate, and the people of my beloved nation, I offer an unreserved and sincere apology and a commitment to uphold the sanctity that is the Senate in adherence to my oath. I thank you, Madam President.
Public business, government business, bills, second reading. Oh, sorry. Motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, having regard to the interim report of the Special Select Committee appointed to consider and report on the Evidence Amendment Bill 2019, I beg to move that the committee be granted an extension to December 31st, 2019 to complete its work and submit a final report. Thank you.
Senators, the question is that the Special Select Committee appointed to consider and report on the Evidence Amendment Bill 2019 be granted an extension to December 31st, 2019 to complete its work and submit a final report. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Madam President, I beg to move that an act to amend the Criminal Law Act, Chapter 1004, the Prisons Act, Chapter 1301, the Police Service Act, Chapter 1501, the Immigration Act, Chapter 1801, the Fire Services Act, Chapter 3550, and the Customs Act, Chapter 7801 be now read a second time. Madam President, the criminal justice system is comprised of many cogs in what is understood to be the system. On the one hand, we have, of course, the judicial system comprising the courts in which the law is heard, interpreted, decided, and delivered. And on the second hand, we have the several actors in this particular matrix, all of whom in very important focus are captured in terms of law enforcement and coordination in this bill. This bill seeks in 7 clauses, Madam Speaker, to address, Madam President, to address recommendations which have passed through the House of Representatives and which seek to tighten the laws in relation to the prison service, the police service, the immigration authorities of Trinidad and Tobago, the fire services, and the customs authorities. Madam President, this law was born, this bill was born in an exercise commenced at the Office of the Attorney General. Upon coming into office, Madam President, there was a hue and cry, and in fact, there was genuine concern, evidence-based in legal proceedings, brought by the Prisons Officers Association against the government of the Republic of Trinidad and Tobago. The Prisons Officers Association complained that they had attempted on many occasions to meet with the then government, headed by the leader of the opposition now, to specifically concern themselves with ameliorations to the law which would protect them. In fact, there were 3 occasions of correspondence passing to and from the Prisons Officers Association to the Honorable Leader of the Opposition, then as Prime Minister, asking for specific attention to be focused upon improvements to the prisons service. Regrettably, that did not materialize, but fortunately, in the continuance of governance, as an incoming government must, the Office of the Attorney General focused upon this issue in a very square term. Specifically, as Attorney General, I invited the Prisons Officers Association and the Prisons Authority to sit with the Attorney General's office, established a working committee comprising the Law Reform Commission, and we set about to address the concerns by an active drafting process of law. This type of engagement is one which, of course, the Office of the Attorney General has used on umpteen occasions, where we invite stakeholders specifically into the office to sit and draft what is required in an environment where all minds are effectively put onto the table. This specialist committee, comprising the officers of the Prisons Officers Association, 2nd Division, representatives of the Commissioner of Prisons, the Law Reform Commission, and the Ministry of the Attorney General, in fact, with me sitting at the head of that exercise personally, set about in November 2017, specifically on the 29th, to get about drafting concerns. Two aspects were focused upon in this exercise: what legislative improvements needed to be addressed and what operational structures needed to be addressed. In terms of operational structures, obviously, the provision of firearms to the police service was an issue which arose. The provision of housing for emergency matters where officers' lives were under threat arose. The provision of improvements to the plant and machinery at the prison system arose, and we got about treating with those. As the public record now shows, the Ministry of National Security, through the Commissioner of Police, have in fact handed over firearms to officers at risk. We have addressed the situation of emergency situation for housing. We are in the course of improving plant and machinery at the remand yard, at the women's prison, at the child rehabilitation center. That left us, Madam President, with the issue of the law. And the Prisons Officers Association, in my public compliment to them, in particular today, to the officers of the Prisons Officers Association, headed by Mr. Seron Richards, they sat about and agreed with the government's proposal that we amend the laws with an equal balance and to hold the scales of justice with equal poise. What we agreed upon, and which is found in this bill, particularly beginning at Clause 3, is a formula by which we say to Trinidad and Tobago that all of us stakeholders in the equation, the Prisons Authority, the Prisons Officers Association, the Attorney General's Office, the Ministry of National Security, all of us agree that there is a problem inside our prisons. The expression turnkey in Trinidadian parlance, turnkey, for those who don't speak Trinidadian parlance. Turnkey is the expression many years ago used to express how a prisons officer's job was effectively managed. Their job was to receive prisoners, to turn the key, and to let due process of justice work its way out until they were set free. The situation in Trinidad and Tobago has changed dramatically. Prisons officers have been assassinated, their family members brought under threat. There's an active trade of trafficking in the prisons. I can tell you, Madam President, that in discharge of my responsibilities as Attorney General, I had cause to be at the prisons myself in conducting raids.
Attorney General, just honorable senators, please, I would like to hear what the Attorney General has to say, so it's too early for the crosstalk. All right? Continue, Attorney General.
Thank you, Madam President. I have personally attended at the prisons and witnessed the supervision of raids with arm's length distance. And in the supervision of raids, I can tell you, Madam President, flat screen TVs, grenades, bullets, cigarettes, mobile devices, electronic devices were all found in the prisons. That says that there is a problem, because you have gone from a situation of the prisons being a place where you ought to be confined and put away from life to a place where criminal enterprise operates and does so actively. In complementing the Prisons Officers Association, they agreed that that should be stamped out and that the law needed to be improved, that the rules and regulations ought to be a feature of the management of the system. And they also agreed that in treating with the offenses that we have in the prisons, which are effectively replicated in the police service, immigration, customs, as we see in the fire services as well in the bill before us, they agreed that whilst we put in heavy criminal offenses for trafficking, for possession, for breach of fiduciary duty, at the same point in time, the government, in providing law, should make sure that prisons officers, fire officers, police officers, immigration officers, customs officers were protected by way of the law providing against retaliation, threats to members of their family, to their property, to intimidation, to harassment, and to other forms. And so that's the general construct of this. We took the work from the Prisons Officers Association Committee. We then engaged in consultations with the Trinidad and Tobago Police Service, the Customs and Excise Division, the Immigration Division, the Fire Services Division, the Fire Services Association 2nd Division, the Trinidad and Tobago Police Services Social and Welfare Association throughout the course of 2018. That then brings us squarely to the law before us, Madam President, having given that perambulation of the issues as I just have. And before us, Madam President, in the bill, obviously, Clause 1 treats with the short title to the legislation. Clause 2, we jump immediately to an amendment to the Criminal Law Act, Chapter 1004. And in causing an amendment to the Criminal Law Act, Chapter 1004, we seek specifically to amend the provision contained at Section 6 of that law, which treats with where a person has committed arrestable offenses and a person causes what we call wasteful employment of the police by knowingly making to any person a false report tending to show that an offense has been committed, or to give rise to apprehension for the safety of any person or property, or tending to show that he has information material to any police inquiry, he is liable on summary conviction. As the law is cast right now, the penalty is a fine of a whole $1,000 and 6 months imprisonment. Of course, and is to be read as or. We propose in Clause 2 of the law to amplify that penalty by providing for $150,000 and to imprisonment for 5 years. I'd like to stick a pin. I'd like to say, pursuant to an undertaking that I gave to this Honourable Senate whilst we were treating with the bail amendments and the restrictions to bail, I informed that the Prime Minister had instructed me to look at the issue of a framing law, a law to treat with where persons are framed unlawfully, wrongly, set up for an offence, set up for a charge, to treat with that. I can inform that I held specific discussions with the Director of Public Prosecutions himself, as well as his Queen's Counsel from the United Kingdom, Mr. Jenkins. We explored the issue in great detail, and the DPP urged me not to introduce a statutory offence for framing, but instead to rely upon the common law fixtures, which the DPP has advised strongly ought to prevail. That is misbehaviour in public office, perverting or defeating the course of justice, and also, Madam President, therefore, relying upon where someone causes wasteful employment of the police. There are, of course, other offences that exist, but I want to assure honourable senators that I did take the obligation seriously and had a very specific discussion with the DPP about this position, who has strongly advised against it. Madam President, obviously police time is important, and that's where Clause 2 treats with the wasteful employment of police time. Clause 3 is where we jump to the Prisons Act. The Prisons Act, Chapter 1301, is a law commencing 16th of October 1900. 16th of October 1900. Of course, we had the 1800s law, which as a colony we managed, etc. But very importantly, we're also treating with the prisons rules. And the prisons rules are equally archaic, Madam President. When we look to the prisons rules as currently in effect, they are 1943 prisons rules. We did cause amendments to the prisons rules. those amendments cannot yet be operationalized, because if you operationalize those amendments, you will find yourself in a situation of unconstitutionality because the plant and machinery has not been brought up to standard. I'm able to report that the government has been in an aggressive reformation of the prison service, largely through the head of corrections in Canada, and that has been facilitated by a joint venture between the government of Canada and the Republic of Trinidad and Tobago. And we are at the cusp of doing the physical repairs at the remand yard and at the MSP and other positions. We've already attended to improvements at the child rehabilitation centers, what was previously referred to as the youth centers, under the what was then called, as we call it an acronym, YODA, the Young Offenders legislation. And we have now brought ourselves into a position where we will soon be able to cause the amendment to the law by proclaiming the prisons rules as amended in the last session of Parliament, in the last Parliament, in the 10th Republican Parliament. That is to be joined by the work that we are doing at the prisons as well, in general, in terms of the law, which I am pleased to say has been drafted and is shortly to be taken to the Cabinet to treat with the whole concept of probation, Madam Speaker, and how we deal with offender management. This Prisons Act, Madam President, is proposed to be amended, particularly by the definition of prohibited article being significantly expanded. A prohibited article, as cast in the law as it stands right now, means any article declared to be a prohibited article by the prison's rules for the time being in force. You will note, Madam President, that the law only allows for prison's rules. It did not allow for regulations. We actually propose in the bill before us now, for the first time, the introduction of regulations. Why? The regulations are more nimble, and we are able to treat with them that way, which is why you will see the proposal for an introduction of a new section 22 to the Prisons Act that allows the minister, subject to affirmative resolution, to make regulations to give effect to the Act. In the definition of prohibited articles, we have effectively captured all of the things that we note are in existence in the prisons. That includes dangerous drugs, explosives, firearms, ammunition, weapons, mobile telephones, cameras, sound recording devices, electronic devices. Why? They are actually in our prisons. We treat with articles that also have the effect of anything that the Commissioner of Prisons would consider to be offensive. And Madam President, we therefore, in defining that in a wider category, give ourselves the opportunity to tackle the criminal enterprise in the prisons by way of application of the law for prohibition. We have expanded by a new proposed Section 3 the number of prisons in Trinidad and Tobago. The old law as it stood did not contemplate the remand prison Golden Grove, the women's prison Golden Grove, the Eastern Correctional Rehabilitation Center, the Carrera Convict Prison, the Tobago Convict Prison, or indeed the child rehabilitation centers, all of which are now modern features of the criminal management through the prisons. Madam President, we then go to the proposed introduction of a new Section 8, which treats with prohibited articles. That was last amended in 2010, and effectively it only provided for summary conviction, $25,000 exposure, and 3 years. We have now gone in the proposal in this bill beyond a person who brings in or carries out, bringing in prohibited weapons, prohibited articles, and we now go into the iterations. Someone who brings or throws or conveys prohibited articles, brings, throws, or conveys prohibited articles from the prison, to or from, leaves or hides places, causes another person, knowing a person is a prisoner, gives a prohibited article, or a person who is found with a prohibited article in a prison and doesn't have express authorization. We split it out now. Instead of it being a summary offense, we have gone for an offense triable either way. We allow for summary route and for indictable route. And Madam President, we are, by the agreement of the Prisons Officers Association, now separating out where the offense is committed by a person as opposed to a prisons officer. And in the new 8.2, we propose where a prisons officer commits an offense under this section, he will be liable again on a triable either way route, summary conviction, exposed to a fine potentially of $250,000 and imprisonment for 10 years, and in the indictable route, exposed on indictment to a fine of $500,000 and a fine of 15 years. Madam President, we propose in this bill the introduction of a dedicated offense to treat with trafficking in the prisons by the introduction of a new section 8A. And I want to say that this is a very powerfully important clause because trafficking as it was proposed, as it is managed in the current law, is dealt with pursuant to the Prison Services regulations. In particular, Regulation 20, subclause 2C, which says that you may be subjected to a range of treatment, anything from dismissal down to a fine, abatement of your money, deferral of promotion, etc., because they specifically employ that you will be subjected to the Public Services Commission's regulations, in particular Section 110 of those regs. That, Madam President, is entirely inappropriate in terms of treatment for the trafficking offense. And so we propose an introduction in a new Section 8A of the law, as this bill proposes, where a prisons officer carries out any pecuniary or business transaction with or on behalf of a prisoner, accepts any present or consideration from a prisoner, brings into prison or carries out in a prison, or attempts to carry in or out prohibited articles, etc., whether directly or indirectly for any pecuniary interest, etc., or has any dealing whereby he obtains or might expect to obtain immediately or in the future a benefit of any nature. And again, we propose that that is treated by way of summary conviction or indictable conviction, i.e. trials either way. You can elect for the prosecution in those circumstances. Remember that summary convictions must be brought within a 6-month period. And therefore, sometimes if you miss the boat on the summary time frame, the statutory time frame for summary offenses, it is appropriate, therefore, to allow for the indictable route to bite. Madam President, the new 8B, which Clause 3 proposes, is again a very important aspect. It is in this clause and this proposed new Section 8B that we specifically treat with the taking of photographs, the making of sound recordings, the transmission of electronic communications for persons inside attempting to communicate outside, the bringing or conveying or causing of restricted documents to be brought or conveyed in and out of prisons, or the transmission of restricted documents. And in the definition of restricted documents, you'll note that we treat with the whole concept of a photograph, a sound recording, a personal record, any other document containing information. We deal with electronic communications in the current form. You'd be surprised to know, Madam President, that in the prisons we have found 4G technology, LTE technology, communications on voice over internet protocol, VoIP. In other words, then, they are not communicating on telephones subjected to interception, they're communicating on the internet. And therefore, depending upon technology for interception, there is a significant difficulty which is faced there. I should flag now, it's not laid in Parliament yet, we will be bringing a very powerful bill to amend the Interception of Communications Act to treat with the advances in technology. So I put you upon notice that there's companion legislation to come along with this. But Madam President, we allow the taking of photographs, recordings, etc., to be done only in strict circumstances. Obviously, the concept of legal professional privilege, the access to your lawyer, the provisions that apply in law, those have to be preserved as the rules contemplate and as professional privilege allows. But we are ensuring that a jail is a jail. When you are there, you are in jail. You are not to be exposing Trinidad and Tobago to the running of criminal enterprise whilst you are incarcerated, be it under remand condition or under conviction, of course. Madam President, we propose to specifically treat in a new 8C with the concept of a prison officer accepting a bribe or gratuity or a perquisite, meaning a perk or reward, pecuniary or otherwise. Again, in these sections, we propose both summary and indictable processes. And we have introduced in a new section 8D, very important clause which treats with the concept of tipping off. And I'd like to say, as we propose in clause 3D, the tipping off introduction, we replicate it across the other clauses, 4D, 5B, 6E, and 7B. We introduce the standard, what I call the gold standard for tipping off, which is section 51 of the Proceeds of Crime Act. We are specifically causing, in the services treated with under this legislation, prisons officers, police officers, customs, immigration, and also fire services, that we criminalize a tipping off where there's an investigation for an offense which is ongoing. We're making it an offense for an officer to disclose information. We, of course, repeat the very safeguards coming from the Proceeds of Crime Act, where legal professional privilege is carved out as an important safeguard. We have kept within the strict terms of the formula in the Proceeds of Crime Act, because the concept of tipping off is giving too much of an advantage to criminal empires. Madam President, we propose in amending Section 10 of the Prisons Act to treat with an uplift in the penalties for persons who aid and abet the escape of prisoners. We have seen escapes across the prisons, be they at the child rehabilitation center level or, in fact, at any of our other prisons. It is a phenomenon which has been noticed. The importance of the next clause that jumps out at us, may I ask what time I must end in full time, Madam President?
It's at 2:47.
Much obliged. The importance of the new section 11, which clause 3F proposes, is something which we replicate across the other services again. This clause 3F, which is in pari materia or in equal level to clause 4I, 5B, 6E, and 7B, we introduce here something which we brought to life, this government, when we did the anti-gang legislation. We propose specifically that we treat with assaults and retaliatory action against prisons officers. Why? Whereas we had as we have in the current law in the Prisons Act, for instance, in section 11, an offense if you assault, obstruct, or resist, or aid or incite any other person to so assault, obstruct, or resist the commissioner of prisons or any prisons officer. We didn't go far enough to where society is now. We have introduced the concept of a person who assaults, threatens, obstructs, or resists, so threats were not there before, aids or incites any other person to so do, a prison officer in the execution of his duty, or any person aiding or assisting a prisons officer. That was not in the current law. Why? There are civil aids to enforcement, including persons engaged in the transportation of prisoners, and therefore we need to protect those ancillary bodies to the structures. And we say that if that person with intent to impede, intimidate, or retaliate against the prisons officer while engaged in the execution of his duty, that person so commits an offense. We add specifically the concept of retaliatory action against a prison officer, against his relative, friends, associates, or property of prisons officer on account of the officer's execution of his duties. And we define, for the purposes of that section, a relative to mean, in relation to a prisons officer, parent or step-parent, spouse, cohabitant, or fiancé, child, stepchild, or other dependent, brother, sister, stepbrother, or stepsister, grandparent, any other person whose care and support is the responsibility of the prisons officer. And then we allow for it to be treated either summarily or indictably. That formulation comes from the anti-gang law, which this Senate participated in crafting. We were very careful to preserve vertical dependence, meaning parents and children, as well as horizontal dependence, whether, Madam President, the chatter on the opposition bench is a little distracting.
Honourable Senators, could we please have some silence while the Attorney General makes his presentation? Attorney General, continue.
Thank you, Madam President. I thank my colleagues for their attention as well. It's hard to make a serious contribution if nobody's paying attention, respectfully. Madam President, the fact is we've preserved, and I mean the opposition, we have preserved the issue of horizontal support, meaning dependence in the wider sense. There may be persons who are reliant upon salaries. The whole concept of in the course of your duty is something which has been debated in law. Are you to only be afforded the protection whilst you're in the course of your duty? We've taken from the experiences in the English courts, in particular as to what in the course of your duty means, which is why we have introduced this retaliatory action, saying that on account of the officer's execution of his duties. In other words then, you are upset with the officer, you target the officer. In the last 22 years, there have been over 22 assassinations conducted against prisons officers. We've seen them killed in action. We've seen them killed out of quote-unquote action. We've seen threats to their property, to their family, etc. And this is something that we specifically recommend borrowing from the anti-gang formula. Madam President, you will note that we then jump to the proposal for a new Section 22. Specifically, Madam President, in putting in Clause 3 this new Section 22, we're allowing for a more nimble form of assistance to the law, the power of the minister to make regulations. The current Section 17 of the Prisons Act only allows you the power to have rules. Again, we put it for affirmative resolution. It's not often that a government proposes affirmative resolution, but if you're going to be treating with the prisons, we feel on this occasion it is appropriate to have affirmative resolution of regulations of this type. There is this archaic provision, Section 63 of the Interpretation Act, which is cumbersome and foolish, if I dare say so. I intend to amend it in a bill which will come to Parliament shortly, but until then, we cause the exception to Section 63 of the Interpretation Act, because Section 63 says, if you don't provide in the parent law that the breach of a regulation has a particular level of offense, you're going to be subjected to $500 as the breach. So we have accepted out the application of Section 63 of the Interpretation Act. We're allowing for breach of regulations to be treated with either summarily or indictably, and we've set the maximum at, in summary sense, $75,000 imprisonment for 3 years, indictment $150,000, and offense for 5 years, Madam President. This theme carries across. I've spent a lot of time on the prison side because it carries across into the police service, it carries across into the Immigration Act, the Fire Services Act, and the Customs Act. The Police Service Act, of course, has the need for us to amplify how we treat with certain things. Section 50 of the Police Service Act onward, from letters A up to F, allow for the police to do certain things, to take photographs, to take fingerprints, to come back again to take fingerprints, to take them in respect of deportees and persons at ports of entry, to manage the notices of attendance if you're under criminal investigation, and how you treat with children or persons who are otherwise deemed to be in need of supervision, incapable persons as described in the law. Whilst you're allowed in Section 50F the ability to use reasonable force to take fingerprints, etc., we didn't treat adequately with Section 50H, H as in hotel. We have sought to amend this law from that which was done in 2014 by improving the law to add in that it is an offense to assault, obstruct, or resist an officer in the exercise of his duties, in letters in Section 50 up to 50E, or a person assisting an officer. And we do that specifically because there are persons at ports of entry or persons who are assisting police officers in the course of their duty, and we've sought to manage the proportionality in the use of force and in the compellability of these circumstances. Trinidad and Tobago is going to come to the point where they need to do, we need to do, like the rest of the world has, and say, you must mandatorily give your fingerprints. I can tell you now, I am working on a specific piece of law, which is a unique identification number for every citizen and resident of Trinidad and Tobago, where your biodata will be captured, specifically so that, like the United States of America, where you have a Social Security Services number, we can therefore eliminate fraud and other ills in our society, and that legislation ought to come at you very shortly. That harmonizes with our digitization platform, our Eyes Everywhere platform, and harmonizes with work that we're doing, for instance, in our Joint Select Committee, Special Select Committee, sorry, on the law of evidence and how we treat with that. So there is a whole combination of laws that all articulate together with each other. Madam President, we of course seek to treat with the punishment for serious offenses by Clause 4 amending Section 53 of the Police Service Act. We split it out away from indictment into both summary and indictable treatment. And we treat very importantly with the situation where police have their firearms or their accoutrement, their clothes, their vests, etc., as they say, rented out. And you will see an amendment to Section 53, subclause 2, where we expand under paragraph F, where a policeman pawns, sells, transfers, loans, provides, makes available. We've added in transfer, loans, provides, makes available, etc., arms, accoutrement, clothing, or any public property. It is important seeing the information that come up in our offenses, in the charges before the court, to capture the wider categorization of ills. We again, as I said earlier, treat with tipping off in the same way we did in the prison service. We also treat with where a policeman keeps his property for private benefit in an amendment to Section 54. We amp up the offenses there. We treat with the delivery up of articles upon retirement or resignation or dismissal, again improving the category of offenses. We treat with improper possession of articles supplied to police officers by causing an amendment to Section 56 and Section 57. We borrow from what we did under the Prison Service and the Anti-Gang Act. We cause a new Section 59 to be considered in this clause, which is where we treat with assaults, threats, or retaliatory action against police officers, protecting police officers. If we are going to ask our police officers to continue to stand in the breach, to continue to stand in the fight against crime, we must protect their families. We must protect their property. We must protect them against the savagery that they are exposed to. And this is this Parliament's way of expressing support for the police officers. Madam President, we also amplify the concept of a police officer accepting bribes, etc. And we treat with that in a new proposed Section 61A, a police officer who accepts a bribe, gratuity, perquisite, reward, pecuniary, otherwise, for the neglect or non-performance of duty, and then we split it for treatment in summary route or indictable route. Madam President, we amplify the treatment of offenses for impersonation of police officers. We have seen people complain about people with blue lights and what looks like a police uniform stopping people along the roads, and therefore we ought to amplify the offenses for that management, Madam Speaker. Madam President. Madam President, I turn to Clause 5. Clause 5 treats with the Immigration Act. Now, the Immigration Act is in the course of an overhaul. Why? It is just too archaic. Several governments have attempted to amend the law, taking the long route, which is one perfect product. This government has taken the mantra of just start quite seriously. We propose amendments to the Immigration Act here to treat with assault, threats, obstruction. We treat with the commission of offenses, what we call in Section 41 of the Immigration Act. We've amplified the treatment. Madam President, listen to what you were exposed to in the current law, are exposed to in the current law. Section 41(1) of the Immigration Act. Every person who, for example, willfully assaults or obstructs or resists or interferes with an immigration officer, or issues any false document, certificate, etc., a range of offenses, you are liable on summary conviction for a first offense, hear this, for a fine of $1,000 and to imprisonment for 12 months, or any subsequent conviction to a whopping $2,000 and to 18 months imprisonment. Madam President, that just does not signal the odium which we ought to have for fraud, for threats, for assaults as it relates to immigration officers. Madam President, we propose the introduction of the tipping off clause. Why? In a society such as Trinidad and Tobago, where the immigration authority has a significant responsibility, we have to make sure that if there are offenses that are under investigation, that tipping off is managed. Far too often, the criminal empire knows what is going on because they are tipped off by people, including people in service. I don't say that every officer has a problem, but there are certainly occasions where this has found itself into the court system, and we must recognize it. Madam President, we again treat with a standalone assault and retaliatory action by the introduction of a new section 41B. We treat with offenses and penalties in the amendments, in the amplifications we propose in section 42 of the Immigration Act. And we accept out section 63 of the Immigration Act for breach of regulations. It's not acceptable to be subjected to $500 for breach of a regulation. We've amplified that, Madam President, to allow for even conviction on indictment. Similarly, under the Fire Services Act, Clause 6 treats with the amplification of offenses, obstruction of a firefighter in the course of performing his duties. Fires are not to be taken lightly. You ought to have specific penalties that you're exposed to if you obstruct the serious work of firefighting. We treat with the assault and threatening and obstruction. We treat with it in the summary context and indictable context. We treat with without reasonable excuse failing to comply with the authorized requests of fire officers, and we treat with an amplification of fines that way. We treat with false fire alarms, because we see false fire alarms happening in our country, and you can shut down effectively large enterprises, serious businesses, and it's not appropriate to be subjected to a whole $1,200. That's what the law in 1993 suggested was an appropriate fine for the fire alarm. We've gone instead to a maximum exposure for $150,000, and we're moving from 3 months imprisonment to up to 5 years. Madam President, we treat with unlawful assemblies.
Attorney General, you have 5 more minutes.
Much obliged. Unlawful assemblies by a proposed amendment to Section 49 of the Fire Services legislation. We introduce in a new Section 51A the tipping off provisions, as we've already explained that to apply. We treat with assaults and retaliatory action in a new 51B. We treat with amplification of offenses at Section 52 by going upwards from the very inadequate offenses of $1,200 up to $50,000, etc. We treat with fire officers accepting bribes, etc. We split that out into summary and indictable exposure as opposed to just summary exposure, because we cannot play fast with people's lives. Madam President, we also come now to Clause 7 of the bill, which is the last clause, where we seek to have amendments to the Customs Act. Again, the Customs Act is a long-haul project. The Customs Act is a pre-1962 law. There are saved powers inside of there. There are a number of powers. People may not know this, but the customs officers are perhaps with greater power than the police officers in certain circumstances. The power of forfeiture, the power of immediate and serious action, customs officers rank number 1. It's no secret that their contribution from the customs authority is a large part of our GDP, and we have to take our customs laws seriously. Madam President, that is why we treat with obstruction of customs officers by amplification up from summary offenses. The whopping fine of $1,500, we just can't live with that in Section 5 of the Customs Act. We've moved to summary conviction, exposure to $250,000, imprisonment for 10 years, conviction on indictment to fine of $500,000, imprisonment for 15 years. This will feed into the revenue authority structure. You can't have inadequate offenses and penalties if you're going to take your revenue seriously. Madam President, let me say this. If everybody in this country pays their fair share on the lower limb, more people paying smaller amounts consistently and fairly, our country has the opportunity to be one of the most profitable, spectacular, and decent countries in the world to live in. After all, I'm certain God is a Trinity. Madam President, our society can afford what we wish to do. It is no secret that we have moved away from oil and gas dependence. The oil and gas sector contributes approximately 27% of our GDP, as opposed to 50% where it was in 2008. Our non-oil sector produces the vast majority, and the customs laws have to be ameliorated. We introduced the assault and retaliatory actions. We again treat with tipping off, and we deal with smuggling offenses, etc., in the amendments that we propose, and we deal with customs officers taking unauthorized fees, etc. Madam President, there's more to come. This is a proposed omnibus approach to several focused areas. This law is something that can improve our circumstances. It's something that is, in my view, entirely proportionate. There is umpteen precedent for the treatment of the laws in the manner that we have proposed. I look forward to the contributions of honourable senators as to any improvements that we may make to this law, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Criminal Law Act, Chapter 1004, the Prisons Act, Chapter 1301, the Police Service Act, Chapter 1501, the Immigration Act, Chapter 1801, the Fire Service Act, Chapter 3550, and the Customs Act, Chapter 7801, be now read a second time. Senator Sobers.
Good afternoon, Madam President. I'm very grateful for being given the opportunity to contribute to this particular bill that is before us. But I would definitely want to, before I start my contribution and get into it properly, I would want to take this opportunity to congratulate the Leader of the Opposition for a very good showing at the local government elections on Monday. That being said, this particular piece of legislation, I do in fact agree, is extremely important. Is extremely important. I think for far too long there has been several calls from different sectors within the security service industry or professions that require a lot more deliberation and assistance, and the level of protection to be meted out to them properly. This is a start to get that done. When we consider the persons who make up our security service industry within this country, we have to think carefully as to what they are actually doing. The natural human instinct when a crime is going on and bullets are being shot from various persons within that particular scenario, the natural human instinct is to run from such a situation. You have individuals who are now being trained to run into situations like that. The natural human instinct when a building is burning is to run away from the building. There are persons within this act who are running towards that burning building. The natural human instinct for persons who operate within the prison conditions, dealing with guarding some of the most dangerous individuals within our society, is something that should be lauded. Persons who work at the immigration division, I think we don't really appreciate what they actually do. But immigration officers on a day-to-day basis are the guardians of our borders. They would prevent persons who may have nefarious plans and activities from coming into our country by asking them a series of pointed questions. And the responsibility, the role and the responsibility of customs officers as well too is something that we should also consider to be extremely important as well too. So any piece of legislation that offers them extra protection whilst performing those important and stellar duties and obligations to our society should in fact be welcomed. But in terms of, and I think for some time now, especially too, Madam President, there are a lot of individuals, few of them in number, who contribute to a series of negative and in some cases criminal acts against these members of our security services. And it is an obligation as legislators to defend our security servicemen and women against persons like that. So the random videos that we may see where persons would be heckling police officers whilst in the execution of their duties, this is an opportunity for us as a parliament collectively to see and send a direct message to those persons that these things will not be tolerated. That the random grandmother, as we say, who would find themselves within a scenario to say, oh, they're too wicked, and all of those things are acts that we may laugh at, but they are very serious because they cause a certain degree of obstruction that we should not promote at all. And any type of protection that we can offer our servicemen and women, as I said before, should be welcomed. But in saying that, Madam President, I would want this Honourable House to consider that a balance must be struck as well, so that servicemen and women in our country have a great degree of power. And with that power comes a great degree of responsibility as well. And we are, or this country, we aren't strangers to particular men and women within our service industry, again, very few in number, who have corrupted the system with certain actions that they would have taken. Our press these days are constantly littered with judgments being handed down by our high courts, condemning the actions of police officers, condemning the actions of some prisons officers as well too, and in some instances as well too going as far as condemning the actions of some immigration officers. So that when we are drafting legislation to offer extra protection to our servicemen and women, we must also contemplate that that must be brought against or constructed so that it balances well with respect to the errant individuals who operate within our service industry. As recently as last week, there would have been a judgment that would have been handed down in the High Court dealing with a death at the maximum security prison, where the judge would have awarded, I think, $0.7 million to the family of that person who would have passed away within the prison service, within the prison itself. There was another judgment that was recently handed down by Justice Sipasad as well too, for a person who was also kidnapped by errant police officers and beaten and held in custody for 5 hours. There was also another judgment that was handed down for a person who again was assaulted within the prison service, within the prison, and within the evidence that came out from that matter, persons were made aware that some of the cameras, the majority of the cameras at the MSP, weren't working up to recently since 2015. So there are many instances, unfortunately, that are coming out. I think when I did my last tally, over $2 million in judgments that would have been handed out against errant security servicemen and women for actions that they would have taken against our citizens. And in speaking about that balance, it brings me to contemplate, from the onset, some of the difficulties with this particular piece of legislation. That I was a bit upset that within this piece of legislation there was no mention made of making persons within the service industry personally liable for damages being handed out by the High Court. And I think we have advanced enough as a society to accept that there are errant officers, and those errant officers should be made to pay for the injustices that they met out to the persons within our society. It may not be that we legislate now that they pay the full 100% of the damage that is handed out by the courts, but there should be some type of starting position so that it would send a message to those who are willingly doing the wrong thing within our service industry, that they will now be made to pay out of their own pockets. It cannot be that the state is being forced to pay, as I said before, almost $2 million within the past couple of weeks for errant actions by a few individuals who have no regard for the same law that they have been sworn to uphold, who have no regard for the citizens that they've been sworn to protect. And I thought that this bill, as we are clothing them with the necessary protection, should have also touched on an aspect of that. I listened to the Attorney General's contribution as he made mention of having certain discussions with the DPP and Queen's Counsel Jenkins concerning the framing legislation. The framing legislation is something that I thought should have also accompanied this particular piece of legislation, this bill. But I would also want to call upon the Attorney General to also consider speaking to the Law Association, consulting with them, consulting as well to the criminal bar, because it is my humble opinion that framing legislation there should be a legislation for framing. It shouldn't just be the common law position. And I think that we have spoken about that particular legislation coming to this House as early as the bail bill this year. And I know that the Honorable Attorney General would have given certain undertakings as it pertains to that, so we would have to wait and see. But those are two fundamental parts of this bill that I thought should have been there, but they are absent. And if we are serious about really offering the necessary protection to our servicemen and women, a balance should have been struck, and those things should have been put into the bill itself. Now, Madam President, when I looked at this bill in its entirety, the bill dealt with it introduced a number of things. It dealt with a number of things. There's a new penalty basically introduced as well for errant members of the bar who may take information from persons who may be in custody and utilize it for nefarious gains. I guess other senators may speak on that. It is a reality. It is a reality. I mean, members of the bar, be it criminal, civil bar, whatever, may not want to discuss it or openly say it, but it is a reality that there are very few lawyers who would participate in such activities, and if the evidence comes to light, well, then I hope the TTPS would deal with it accordingly. But we should never bury our heads in the sand and think that it is not a reality. The bill also deals with obstruction, as would have been mentioned before, and tipping off. And in terms of obstruction, it appears throughout the legislation being drafted in a particular way. The construct is mirrored throughout the legislation to touch with respect to the prisons, the police, immigration, fire, and customs. Now, I understand the need and the importance for amplifying the fines and the sentencing as it accompanies persons who obstruct members of the prison, police, immigration, fire, and customs. And in terms of the way in which the obstruction aspect of it is drafted, it offers a significant degree of protection for the officer, the serviceman or woman, and also a certain degree of protection for an individual, a member of the society, who may assist the serviceman or woman within the execution of his or her duties. The obstruction aspect as well too offers this new element of protection against intentional retaliation, which is good because any member who falls within that particular construct of a relative, if there's no aspect or demonstration of intentional retaliation for the execution of the individual's particular duty, then there may very well be a number of persons falling within this particular construct. But what is absent within the obstruction framework is the fact that the construct does not protect a citizen's relatives as well too. So there may very well be a case where police officer A is executing his duties. And as it pertains to police officers, there's also a particular section, clause 4G, which is located on page 21 of the bill, that also amplifies or indicates then that a person who without good or reasonable cause, who does not assist a police officer in the execution of his duties, without reasonable cause, as I said before, could in fact be charged. So if we are more than encouraging citizens to aid police officers, which is laudable, but we don't offer the citizens' families or relatives and their property the same level of protection that we have offered the serviceman or woman, it could put a citizen in a precarious position because you are now being called upon to assist this particular service person. And now your family, your relative, is not going to be offered the same protection that the serviceman has. When these persons, service people, are out in particular areas, and you, a citizen within that area, may see a police officer getting stressed to execute his or her duty, and you are a member of that community, go out to assist that policeman or policewoman, and the other individuals within the community who aren't doing anything to assist in the situation, watching you, that citizen, adhering to your call, your civil duty, under the legislation now as we are creating it. What you think gonna happen when you go back home? They may not attack you, but your relatives are now at risk. Your house, your property is now at risk. And we should offer that same blanket of protection to citizen A or B or C who assist the police officers in terms of executing their duties, as we have done for police officers and their family. So that is the first, the issue that I have with respect to the obstruction framing. The second thing with respect to tipping off. So tipping off is equally located, the construct of the yes.
Thank you very much, and I'm honestly enjoying your contribution. Throughout we have, in relation to the protection of the other persons, we've specifically included in the retaliatory clause, for instance, a prison officer in the execution of his duty, or any person aiding or assisting a prison officer in his execution. Is it something beyond that that you were looking for? And if so, could I trouble you to guide me on that?
Of course. So, all right, so let's look at the police. That's on page 20, right? So at page 20, clause 4I, I think it is, the way in which it reads is, a person who, and you go through assaults, threatens, obstructs, or resists, and then it goes down to a police officer in the execution of his duty, or any person aiding or assisting. So it covers the police officer with respect to the obstruction, and it covers the person who may be assisting. But when you go down to part 2, it reads, a person shall not intentionally take any retaliatory action against a the police officer and be the relatives, friends, associates, or property of a police officer. But it does not contemplate the relatives, friends of the citizen who may have been assisting the police officer as well too. And those persons, because it's a community-based situation that may very well arise, may find themselves at risk. So I'm saying that we should amend to assist them as well too. Yeah. And then in terms of tipping off, so again, so tipping off is located throughout the legislation, the bill before us. And so an offense is created for persons within the society, citizens who may tip off members of the criminal element and whatnot, to investigations, to a raid or whatever that may be taking place. And I think it is laudable that we actually have created an offense for such actions. But what I think is missing as well too here is that the particular service individual, so you as a member of the public, you have A or Y information about a raid that is going to take place tomorrow at dawn or whatever the case is. And you go and you inform the elements that are going to be the subject of that raid, or you inform an element of the subject of an investigation that is currently ongoing, that has reached a critical stage. But the question is asked now, where have you procured that information? It must be that you receive that information from a member of the service industry, right? So it is definitely that a member of the police service, or a member of the prison service, or a member of the immigration, fire, or customs would have provided you, citizen A, with that information for you to now go and tip off these criminal elements about this impending raid or this investigation. But the legislation as it is framed currently, or is being offered, does not provide an offense for the service person who provides this information to person A to actually go and tip off. And I think because the source of the information would inevitably be that member of the service industry, he or she should carry a greater penalty should be affixed to that person. And it is absent within the current bill that is before us. So those are two important points, because obstruction and tipping off is littered throughout the bill before us. And I think those were two important points that are extremely pivotal and were missing when it comes to obstruction and tipping off. Now, getting into the bill again specifically, I looked at clause 2, which dealt with the Criminal Law Act and the amendment. And I mean, for far too long, there have been many persons who would make false reports. I mean, that's sometimes is almost a common occurrence on a weekly basis of persons making false reports. And because the penalties are were so low or are so low currently, that police officers tend to basically just reprimand the individual in some instances as opposed to charging and going through the process. Now that we have, or at least proposing to raise the fines and the penalties and amplify it a lot, it is a welcomed approach because it would warn persons off from committing such an act. And why this was significant to me, there's an epidemic in the States, and we in Trinidad, to an extent, we like to copycat. So there's an epidemic in the States called swatting. And what swatting is, it really started with video gamers. So gamers would be online playing all these video games online. And because you're battling persons within the US and you may know the person's tagline and where they're from, to distract them whilst this game is ongoing online, they'll pick up the phone and call the police and say, listen, in X house, it have a bomb that's about to go off. And all you need to go down there, no. And the SWAT team would go down there. Yes, that's exactly how it started. And it's an epidemic in the States called swatting. And I am informed from members of the service as well too that there have been 1 or 2 instances in Trinidad where instances like that have in fact occurred. So I think this is extremely serious that we nip that in the bud now to ensure that persons don't adopt such a foolish approach in wastefully employing police time, right? So I wanted to really put that on the record because it is an epidemic in the States and it should not ever be allowed to reach our shores here in Trinidad. Now moving on, when you look further, we start getting into the Prisons Act. Now, Clause 3C of the Prisons Act. No, actually the section that deals, Clause 3D, that deals with trafficking. Now, trafficking in the prison service is also a very serious offense. It happens on a daily basis. And I thought it was a good attempt to craft legislation to treat specifically with trafficking because, as the Attorney General indicated, it is only dealt with within the regulations, and the sanctions that accompany trafficking is very minuscule. It's not even, it's a waste of time. So that in terms of creating legislation to treat with trafficking, it's a good step. But my issue with trafficking, or the way in which it's constructed here, is that what was not done is that there's no contemplation for how trafficking actually occurs. Trafficking, as it is crafted here, it's specifically to deal with the prison officers. But trafficking involves a chain of persons. So you would have instances where it would start with the person within the prison would inform a relative as to what it is required, what is the particular item in the prison service at that point in time that is a hot seller. And that prisoner may inform a relative, well, listen, we need to get X amount of cigarettes within the jail. And the relative now, who forms part of this criminal chain now, would go and either, in some instances, approach maybe the lawyer or approach the police officer now to get the item to the prisoner while they're in the courthouse. Because that's where the majority of the items would flow into the prison. Really? Yeah. Right, so there are several persons throughout the chain that should have been addressed with respect to this particular trafficking legislation. And one of those persons, I know the time running out, yeah. One of those persons, so the construct of the legislation only deals with the prison officer, and it should also have contemplated treating with both the police officers who would assist in such stuff at the courthouse, any other individual connected to it, be it the lawyer or the relative, who assisted in terms of bringing the item, And also, the prisons officer is actually the last person on the line when it gets to the prisons itself, because in terms of the random searching, if the prison officer is paid properly, well, then they will forego making that person strip and do the squats and whatnot, whatever obtains there. So that is something that I think it was missing with respect to the trafficking aspect of the bill before us. Now, Clause 3D also makes a specific offense for, well, it has restrictions and penalties for transmission of videos and messages. And when I read this, it immediately brought me back to the second year of my call when, you know, we had to adopt a particular approach to a particular client that we had and stop dealing with the client. Persons have to understand within our society that, again, a jail is a jail is a jail is a jail. So video recordings glorifying persons liberally walking through the prisons, smoking marijuana within a prison should never be allowed to see the light of day. And any person transmitting such videos should be penalized. But going further into the sting behind such activities is the fact that within some of those videos that you watch, there are coded messages that are passing through to the viewers who they intend to reach. Messages that would instruct persons upon how to continue illegal and nefarious activities while these gang leaders and bosses are currently within the prison. Coded messages that would instruct individuals to commit hits upon persons as well too are found within these videos, are found within normal text messages. And that is one of the main reasons that it is extremely important for us to ensure that this particular construct is allowed to stand. Apart from the coded messages of hits and instructions to continue trade on the outside, the one aspect of the construct that it does not touch on is the fact that I think apart from the prisons officers and maybe the prisons officers who may be charged under this particular legislation for sending these messages out, the persons, the civilians on the outside who are participating in these activities, they should be charged. Because there's nothing that you could tell me as an attorney that would encourage me to allow you, a citizen or a civilian on the outside, to be taking any phone call from any prisoner whilst they're in jail. You want to see the person, there are particular hours at the maximum security where you could go and see them, go up there and sit down and wait. Yes, the service should be a little bit more efficient because we as lawyers, when we go there to see clients as well too, we have to wait sometimes hours before persons are brought for us to see them in a barrister's room. But I would never be in support of any citizen being able to take any phone call or any video or anything like that from any person within the prison walls. I can tell you without a doubt, without reservation, when I used to practice criminal law heavily, any time a client calls me from prison, I used to hang up the phone. I'm not going to encourage that, and I would never want, especially now as a legislator, to put it on the record that that should be encouraged. So any civilian involved in such activity should also be caught under this legislation and be charged accordingly. So the bill also deals with the Police Service Act as well too. And Clause 4C of the bill is amended to treat with situations where police officers would rent out equipment, clothes, guns, and whatnot as well too. And I think that is a welcomed approach because for far too long now, we have had several situations within the public domain where persons have been utilizing clothes and equipment and committing illegal acts upon our citizens without proper abatement. So crafting legislation to specifically deal with situations like that is in fact a welcomed approach. All right. In terms of the Immigration Act now, I have practiced immigration law for quite some time. And it has always been a pet peeve of mine when persons, foreigners, are charged under the Immigration Act, in particular Section 40 of the Act, for a number of offenses, be it entering the country illegally, being in possession of a false or fraudulent passport, being in possession of a legitimate passport but with a false stamp, being in possession of a legitimate passport with a legitimate stamp but with a false signature for extension. All of those offenses in Section 40 of the Immigration Act, from A to G, the penalty is 3 years imprisonment and $50,000. First-time offenders, everybody coming before the court, that is the penalty. But when one looks further at Section 41 of the Immigration Act, you'd have a situation where the immigration, so it was highlighted by the Attorney General, a particular part of the Section 41. But my commendation with respect to increasing the penalty under Section 41 squarely lies that it brings immigration officers definitely within the framework of being properly penalized. Because previously, as the Attorney General pointed out, you would have been fined $1,000 and I think 2 months in prison. When someone is held with a passport and there's some question as to the validity of the document in their possession, that passport has to be sent to the forensic center. Immigration has a forensic center at the Piaco International Airport, where they will run certain tests on the passport to determine the validity of the passport, the validity of the stamp, and the validity of the signature. I have had numerous amounts of clients who would have been charged under that same Section 40, coming before the courts, and upon taking instructions, I am told that they would have been brought to an immigration office, sometimes in San Fernando and in Port of Spain, would have met with an immigration officer who was in uniform, who gave them the stamp for the extension on their passport, and then do a little chicken scratch signature and tell them, look, take that. So when they are caught in a roadblock or in a raid, and the immigration checks the passport, each signature upon a stamp corresponds with an officer, because the stamp that is located on a passport is assigned to a particular immigration officer. So the immigration officials know that there are errant officers amongst them, several of them. There's no way you as an immigrant or an individual or a foreigner would be in possession of this stamp without having visited an immigration officer. There are very minor situations where the stamps themselves are out of circulation or rotation as they are, and an officer would carry home a stamp or whatever and affix it upon a person's passport. And after all of that, after highlighting this on a number of occasions in the media and elsewhere, at that juncture, the law was not changed to bring immigration officers into proper question for their errant activities. If ever they were charged, basically compared to what the migrant or the foreigner would have gone through, they would just get a slap on the wrist and just get a fine of $1,000 if ever charged. So to increase the penalties now for these errant officers, I think is a definite welcomed approach. It cannot be that we are continuing or continue to do business as usual when these officers are the ones, in some instances, very few in number, taking advantage of persons within our country, the foreigners especially. And to finally craft legislation to treat with a situation like that is something that I would definitely support. As it pertains to customs, there was a section you sure about that? Yeah. Where a customs officer would have simply been, the legislation allows for an amendment to just the actual dismissal of the customs officer as opposed to increasing fines and penalties for that particular customs officer. I think in terms of the committee stage, I would want to raise an issue as it pertains to the wording of that particular section. But Madam President, all in all, as I said at the beginning of my presentation, I do believe that the time has definitely come for us as a parliament, for us as a people, to offer the necessary protection to our servicemen and servicewomen. But as I indicated at the start, we need to conduct a proper balancing exercise to ensure that servicemen and servicewomen, given the responsibility that they have to our citizenry and to our country, that they are also held to account for the wrongs that they may do and that they purport upon citizens within this country. But as it pertains to the current ambit of the bill, with maybe some minor changes, I think it is a welcomed approach, and it would redound to the benefit of the servicemen and women within our country. I thank you.
Senator Deonarine.
Thank you, Madam President, for the opportunity to contribute to the debate on the Miscellaneous Provisions Law Enforcement Officers Bill 2019, which seeks to amend the Criminal Law Act, the Prisons Act, the Police Services Act, the Immigration Act, and the Fire Services Act, and also, in addition, the Customs Act. We are presented here today for yet another time legislation in an attempt to deter criminal activity in Trinidad and Tobago. The bill seeks to primarily do two things: increase protection to law enforcement officers through increasing the fines of various offenses that range from the use of prohibited articles, resisting assault, refusing to assist an officer in need, tipping off, to impersonating members of these law enforcement services. It also attempts to increase the fines for those law enforcement officers charged with misconduct in many forms. My approach to this bill today is brief and more an overall interpretation and I will comment in the context of our fight against crime and violence, as opposed to a clause-by-clause review. So, Madam President, why do we need to increase the protection of law enforcement officers? Is it because the surge in crime over the years have made the jobs of law enforcement officers more vulnerable in their respective lines of duty? The job is obviously riskier today as criminals are finding themselves innovative ways to sabotage the jobs of those protecting and serving. Or is it because of the growing number of reports of police officers involved in crime, such that citizens are increasingly treating law enforcement officers with less respect, and as a result, we need to penalize the persons who misbehaved with them? All of us are very well aware of the bad reputation that law enforcement officers get when we see headlines like, and I am quoting, 3 police officers held in connection with $30,000 theft, $350,000 in bail for cop on drug charges, $750,000 bail for cop charged with accepting bribe, safety officer assaulted, beaten by cops in the police station, judge criminally inclined officers in the Trinidad and Tobago Police Service. So, Madam President, we all know that the list goes on. It is quite easy for the public to make generalizations of the entire police service, prison service, customs, and immigration services based on the criminal behaviors of a few. Because law enforcement officers are meant to protect and serve, and they are expected to respect their officers. Even one case of abuse of their power is too many. But when the public hear the reports, some part of us say, thank God they are caught, but another part of us are wondering how many more of them are corrupt. It does something to public confidence and trust. According to the Global Competitiveness Report 2019, the reliability of police service in Trinidad and Tobago was ranked as 122nd out of 141 countries. Although this is an improvement from the 2018 report, where we were ranked as 128th out of 140 countries, which I am assuming correlates to the appointment of Commissioner of Police and his associated interventions, But being in the bottom 20 countries on a global scale says something is seriously wrong. The people are having problems depending on the service. Madam President, while it can be quite attractive to increase penalties for breaches, how are we going to ensure that the increase in penalties is translated to increased accountability in the services? How are we going to ensure there is sufficient oversight? While it may be clear that charges associated with misconduct, bribery, and corruption in all these services need to be increased, detection of criminal misconduct in the service must be handled more swiftly, and persons must feel safe in reporting such acts. More importantly, identification of misconduct may be prevalent, but how are we going to encourage reporting of misconduct both within these services and among the population? How much of the population is aware of the role of the Police Complaints Authority and the avenues that exist through this independent authority for filing claims? We need to have campaigns informing the public on the avalanche of amendments to criminal laws that we make on a regular basis in this Honorable House. Besides, when the Police Complaints Authority completes an independent investigation and makes recommendations to the Director of Public Prosecutions, the criminal charges to be laid or criminal charges to be laid, the Commissioner of Police, for example, also has to put in place disciplinary offenses, and we expect that action must be swift. Depending on the type of investigation being conducted, on average, a murder allegation takes almost 1 year with the Police Complaints Authority, and for assault allegations, investigations can take almost 4 months. After recommendations are made, then the case enters the courts, where we all know bottlenecks do exist. Even prison officers caught in corrupt practices have very low conviction rates due to timely processing. Matters are stalled for years and sometimes eventually dismissed. According to the 5th report of the Joint Select Committee on National Security, 3rd session, 2017-2018, of the 11th Parliament, on the final report on the Police Manpower Audit Committee, laid in Senate in this Honorable Senate on July 2nd, 2018, over 40% of all ranks and ages of officers stated that corruption in the police service exists either very much or much, with a higher proportion of young officers feeling this way. In fact, the report continued to say that over 48% of officers with less than 10 years service felt that corruption in the service exists very much or much. This is on page 71 of the report. As you continue on page 71 of the report, the Joint Select Committee on National Security was told that there are officers who refrain from whistleblowing because of their fear of reprisal. This creates a challenge to gathering the evidence to support suspicions of wrongdoing within the police service. In the prisons service, for example, the Commissioner of Prisons gave insights into a recent crackdown on corruption prison officers. It was aired on the morning edition on TV6 on January 8, 2019. He indicated that there are challenges in terms of the technological deficiencies, such as scanners, etc., to scan prison officers. He also mentioned that despite ongoing monitoring to ensure prison officers don't pass through the system with drugs, it is made even more problematic because of the configuration of prison dorms. They do not meet international standards. The issue of cell phones by prisoners and also prison officers continues to be a problem. And though I understand a threat analysis unit was established in the prisons, I am not sure how effective this unit has been in terms of finding these corrupt prison officers. So, Madam President, being a little bit forward-thinking, I cannot help but ponder what effect the application of these penalties would have on breaches under the different acts. What would be the impact many years from now, 2 years from now, 1 year from now? At that point in time, we should be in a position to say whether or not the increase in penalties lead to a reduction in breaches by prison officers, police officers, immigration officers, etc. Absence of rigorous evaluation. In the absence of rigorous evaluation, the effectiveness of these measures cannot be concluded with certainty. This brings me to the point on crime and violence, data collection and analysis. Correct me if I am wrong, but currently I'm not aware of any law that governs the collection of and the sharing of data relating to crime and violence. Currently, the Crime and Problem Analysis branch of the Trinidad and Tobago Police Service collates official crime data, both at the divisional and at the national level. Therefore, this division determines what data is useful and both at the divisional and the national level. This unit is responsible for collecting, processing, analyzing, and dissemination of crime data generated by the Trinidad and Tobago Police Service. So, Madam President, legislation that continues to come to the Senate to deal with escalating crime mostly focus on measures which seek to come into effect after the crime has actually occurred. And it also focuses largely on increasing penalties. Studies that look at crime and violence from a public health standpoint, criminologists since 1976 have argued that exclusive reliance on suppressive approaches tend to fail since they fall short in identifying and addressing the root cause of the problem. And as a consequence, the criminal justice system becomes overwhelmed because the rate of illegal behavior may increase to the point where the justice system lacks capacity to adequately deal with the number of cases. Does this sound familiar? Now, reverting to my opening statement where I said we are here again to pass laws in an attempt to deter the rampant crime situation. We have passed a multitude of legislation since my time here in an attempt to assist the government and the Commissioner of Police in the fight against crime. We've passed 2 bail amendment bills, the Civil Asset Recovery and Unexplained Wealth Bill, Firearms, Magistrate Protection, Proceeds of Crime, amendments to the Financial Intelligence Unit, Non-Profit Organization Bill, Sexual Offenses Bill, just to name a few. But while we do so, it seems as if the crime problem in Trinidad and Tobago is mushrooming, and it is mushrooming at a faster pace than these laws can seem to fix. Gang culture has become more entrenched in Trinidad and Tobago. And I say this based on my daily perusal in the newspapers, of news in the newspaper. So, Madam President, the amplification of penalties is okay once you have sufficient oversight of the Trinidad and Tobago Police Service, the prisons, the immigration divisions, and customs officers. We have to ensure that organizations exist such as the Police Complaint Authority, such that they are fully functional and fully operational and have the necessary powers to deal with misconduct. With those few words, Madam President, I thank you.
Minister of National Security.
Thank you very much, Madam President. Madam President, it is indeed a pleasure to have the opportunity once again to join the debate in the Senate. And Madam President, I'd like to emphasize at the outset the importance of this bill and the passage of this bill, not only to the government of Trinidad and Tobago, but also to the officers, the men and women in the various services and the divisions of national security, who this bill touches their lives directly. And at the beginning, I'd like to place on record my personal thanks to the Attorney General and the former Minister of National Security, Minister Dillon, for them listening to the cries, which are the genesis of this bill, of the Prison Officers Association, and then for them doing the hard work, and I came in at the end to assist in the mopping up and working with the Attorney General to produce this bill, but also to thank the Attorney General for piloting it this afternoon. In fact, he was surprised I'd asked him to pilot it because we're juggling a whole host of things. Madam President, lest anyone in the Senate has a disconnect, or not to use the word disconnect, but doesn't understand the genesis of this. The plain genesis of this bill came from a request of the Prison Officers Association, who felt, and rightly so, that they were under particular attack by the criminal elements in society, some of whom, unfortunately, are behind the prison walls. And it came at a time when the prison officers felt that their membership were being singled out by certain elements in the criminal empires, including behind prison walls, and targeted. And unfortunately, it led to a couple murders of prison officers. So one of the things when we met with the Prison Officer Association is they said, increase the penalties, increase the sentences for those who target prison officers. And we listened to them. And then the Attorney General, in his wisdom, turned around and said, and it forms the mantra of this particular legislation, well, if we're going to protect you in that manner, and we're going to increase the penalties in an effort to offer you that extra sense of protection, and I repeat, when we sit in this Senate and in the House, all we can do as legislators, whilst in the Parliament, is pass law. So it always amuses me to an extent when I hear persons suggest, well, all you're bringing is law. All you're bringing is legislation for debate to solve crime. That is the only thing that can be done in the Parliament. There is nothing else legally that I am aware of that parliamentarians can do to contribute to the fight against crime, apart from being advocates on the outside against crime, but most importantly, charged with the responsibility, be it in the House or be it in the Senate, to pass legislation to take the fight to crime. So to get back to the point, we said to the prison officers, if we are going to increase protection for you and your membership and your family members via legislation, it comes with the flip side of responsibility. You pick up one end of the stick, you must pick up the next end. So on the same hand, we understand, or on the other side, we understand that there are prison officers who engage in corrupt acts and activity. And this is unfortunate. And as I tell them on every occasion of interaction, once you go down that slippery slope and you cross the line once, there is no coming back. And the prison system is the perfect example of that. Because unfortunately, the prison officer who falls prey to the criminal element within the walls whilst performing his or her duties and thinks that they will take that simple one-off act to take a cell phone in or to take prohibited goods in for prisoners on that one occasion, that is the beginning of the end for them. And they're on that slippery slope, and there is no coming back out of it. Because as we see in the prison system, and we are aware, we're not burying our heads in the sand, we are aware of the difficulties taking place in the prison system. And you would have seen, Madam President, as the population would have, over the last few months, we have increased the asset base at the prison system. So we've also gotten dogs, and we thank the US government for that. That helps. We've increased the searching of persons going in and out of the prison system. And almost unfortunately, on a weekly basis, fortunately and unfortunately, on a weekly basis, you're seeing the busts of prohibited items and the attempts to get them into prison. The difference is that we're making inroads and we're actually picking up the items before they get in. So this legislation, on the flip side, increases the penalties to the prison officers if they engage in any such activity. They engage in the helping. I've heard all of the conversation. I'd like to take the opportunity, because I was listening whilst I was in my office, to Senator Sobers. I was pleasantly surprised. And when we have those types of contributions, we should say so. And we should say that as citizens, we appreciate, and no pun intended, with the sober conversation and the way that Senator Sobers presented his discourse to the Senate. And I want to place that on the Hansard. So this piece of legislation here today, as you've heard before, deals with the prisons, the police, immigration, fire, and customs. And I'd like to focus initially on the prisons. There's also a section in this proposed bill that has been passed by the House that deals with a very important, prevalent problem that we're facing in the prison system right now. And that is the use of devices, and the use of internet, and the use of social media, and the use of what is deemed here electronic communications via devices, to not only communicate directly with the outside world, but also to communicate via putting things up on social media platforms. I see Senator Sobers has returned. Senator, in your absence, I took the opportunity to tell you what a good presentation you gave and how refreshing it was. So in your presence now, I repeat it and I thank you. Don't let those water it down. So electronic communications is covered in this legislation. And I just want to tell the population that we're very aware of those both inside the prison system and those outside of the prison system who are using electronic means to communicate in an illegal manner. And the Attorney General, after listening to it and seeing the reports, brought this particular section for us to deal with it. So for the first time, we will have it as an express statutory criminal offense for the posting on social media platforms, but also the voice over internet conversations. So the WhatsApp conversations that may be taking place and these other means of communicating, which are really the continuation of the criminal empires on the outside by the criminals who are incarcerated. And as Senator Sobers said, when you're in jail, jail is for jail and it's all about jail. And he's right. And this particular section goes directly to the heart of ensuring that a jail environment is a jail environment. Because you see, despite what people may think, at the end of the day, one of the reasons for incarcerating people is to take away some of their liberty. You mustn't treat them cruelly, you mustn't treat them in an inhumane manner. And we work towards those things, the improvement of the conditions. But there must be no free flow of communication. And it is a fact that right now there is too much, because one conversation is too much. There is too much communicating going on with those in the prison system and those on the outside of the prison system. And again, it's an opportune moment to put down yet another marker that those in the prison system who are incarcerated, some of them for murder, continue to communicate with the outside world to carry on their criminal empires. And unfortunately, sometimes the people who are falling prey to being the communication tools in those instances are the lawyers in our society. And every time we say this, there's an outcry, but it is a fact. And now this legislation is a step in the right direction to criminalize that type of activity. Of course, lawyer-client privilege and confidentiality and those conversations are fine. But when you step over the line and you're now assisting in the carrying out of criminal activity and a criminal empire, that is something the authorities have requested of the government via legislation, that specific criminalization of that activity takes place. What this legislation seeks to do for the prison officers is to increase the fines, the penalties for those who attack prison officers and their families and threaten their families. But it also, as I said, at the proposed introduction of Section 8A, which falls under, I believe it is Clause 3 of this legislation. Correct, at Clause 3 of the legislation, the proposed new clause, Section 8A, it deals with trafficking in prisons by prison officers. And this is the particular section, Madam President, that I was referring to, that we're telling prison officers, don't go down that road. Don't assist in the provision of tools for the carrying out of criminal activity. So if you do so, we're increasing the fines and the sentences and even imprisonment with respect to those prison officers who may find themselves in those particular situations. Then when you go on and you look at the proposed Section 8B and the other offenses related to prison security, this is where now we're dealing with voice over internet protocols and communication and social media, and to deal with persons making videos, etc., and transmitting it from within prison. And you're right that we've seen the videos. In fact, just yesterday, some were circulated. I think they were old videos of a certain gang or members associated with a gang within prisons carrying on and seem to be smoking certain illicit drugs and saying how they will continue their criminal empires. So we're telling them that is unacceptable, and we're passing legislation specifically to deal with it. But also, as I say, the electric communications that are taking place. A lot of discussion was had about tipping off. And I want to join with the Attorney General in saying that the need for tipping off legislation and to criminalize tipping off with all of the various services that this particular bill seeks to deal with and to capture are necessary. Because just this week, in a particular briefing, the Commissioner of Police, the Chief of Defense Staff, and the Director of our Intelligence Services and myself were being told of, just last weekend, a particular operation being planned and about to be implemented, one that had been in the planning for quite a while. And as they set off, it became apparent that there was tipping off. And we're saying that when you do these acts of tipping off, which are the servicemen and women, you're putting at risk the lives of your fellow officers. And we're finding ways, from a practical, logistical point of view, to try and get around it. And this is not unique to Trinidad and Tobago, unfortunately. The criminal tentacles have a way all over the world of reaching from top to bottom. But once again, the Senate today can show its commitment to provide the tools via legislation. And that is all we can do via the Senate and via the House. Provide legislative tools in the fight against crime. And I heard the remarks that the government, all this government has done, or a lot of what this government has done legislatively, is bring legislation to deal with crime. And that is because the commitment of the government is understanding, as I've said on numerous occasions in the Senate over the last few months, the reality of crime and how crime is affecting. And this is what we can do. The passage of pieces of legislation to deal with the evolution of crime that is continuously evolving, almost on a daily and a weekly basis. The legislation must keep up with it. And we can't criticize the bringing of legislation to deal with it. and criticize and say, well, why didn't you do this previously, etc. We can't change the past, we're dealing with it now. We also here are increasing the penalties for prison officers accepting bribes. I think it's obvious why we would want to do that. So what we're saying to the prison officers, and interestingly, just before coming here, I was speaking to Seren Richards, the president of the Prison Officers Association. And they're happy and they're waiting for the passage of this legislation because they worked with us on the creation of this legislation. Importantly, assaults and retaliatory action against prison officers found at the proposed Section 11 amendment to the Prison Service Act. And we're saying any person who assaults, threatens, obstructs, or resists, or aids or incites any other person to assault, threaten, obstruct, or resist a prison officer in the execution of his duty, or any person aiding or assisting a prison officer in the execution of his duty with intent to impede, intimidate, or retaliate against a prison officer while engaged in the execution of his duty commits an offense. Madam President, this is the provision that they're looking for, meaning the prison officers. This is married and coupled with the firearms they've been provided with, the stab vests they've been provided with, the other areas of national security we're working with through multi-agencies to offer our prison officers, the men and women who go out there and do their duty as prison officers, to offer them that extra protection. Not many people would have had the opportunity to tour the prisons and to see what it is that prison officers on a daily basis face and the difficulties of their environment. So whatever we can do to make their lives that much safer, that much more palatable, I say to you, the senators here today, this is one of those occasions that you can assist them. We then, in this bill, move on to deal with the police service. And again, you start off immediately by introducing increased fines and sentences for those who assault or resist or obstruct officers in the exercise of specified functions, in the exercise of their duty. Unfortunately, we see all too often, again via social media, that on occasions when our policemen and women go into certain communities to conduct their duties and to exercise their authority in a lawful manner, what they're faced with and the attitude and the pushback that they get by the community, certain elements of the community. And as we talk about in our briefs, our briefings, and when we're planning, you're seeing very often now the use of women and children when the police officers go in. And they are now being used by the tools to prevent police officers when they're going in to carry out their lawful duties and activities, to prevent them from doing so, to make it more difficult. This is an opportunity for us to send a signal to them. There are certain things that are being done on the operational side, and I'm sure the population will see in the not too distant future. But legislatively, this is the opportunity for us to put down our stamp, to put down our objection to that type of behavior when our men and women in Trinidad and Tobago Police Service and the Fire Service and our immigration officers and all of the other officers this covers are carrying out their duty. And I say respectfully, Madam President, it is a most important amendment being made to show the change in times. I'm sure when everyone in here was younger, you would recall when you saw police officers on patrol and the police vehicles going into certain areas, the respect that they were given. We need to show society, and it's the minority of those in society, that we stand up here as legislators and provide that level of support by saying it's not going to be a $500 fine. It's not going to be a $1,000 fine. This is serious when you obstruct police officers in the conduct of their duty. And we're sending a strong signal here. Again, the tipping off. Tipping off is important. This particular offense in dealing with some of the operations, or a lot of the operations that the police service go through. The Commissioner of Police himself and the executive are continuously battling with this problem. You saw the Commissioner of Police yesterday in a press conference talk about how difficult it is sometimes when you have police officers taking photographs and leaking photographs of station diaries, etc. The next section, dealing with police officers, again deals with assaults and action against the police officers. And it's us sending the signal that that is unacceptable. Police officers accepting bribes. There was a particular section in here that when we had dealt with it in the other place, it drew the attention of the public that some people weren't aware of. What we're also doing here is we're seeking in this bill, Madam President, to increase the fines and the penalties for those who provide officers whilst on duty with alcoholic beverages. And persons can immediately understand in our society, and the prevalence of that unfortunately taking place in our society, of this as a fact. Very often I am sent messages and photographs of police officers on duty, or you'll see they'll send me pictures of a police vehicle, a marked police vehicle outside of a bar, or police officers with alcoholic beverages in their hands, driving motor cars, etc. So again, we're sending the signal via legislation that we think this is unacceptable. Immigration. Our immigration officers, so for example, when you go down to, when I went down to Cedrus and I toured the immigration office down there, the officers down in Cedrus told the very real examples that they faced at a time before the registration process, where locals would turn up and threaten them that if they didn't give passage and they didn't allow certain immigrants in, etc., what could happen and these types of things. In fact, we had one incident with an immigration officer up at Piarco saying that she was followed to her vehicle by an individual who is making a living, it appears, out of trafficking of persons. So what we're saying here is we also capture the immigration officers to provide them with that extra assistance. And as I heard Senator Sobers say, the live examples of, unfortunately, the bad apples, even in the immigration service, who may be providing the false stamps or assisting in the committing of illegal offenses and offenses against the Immigration Act. So we're telling them, on the one hand, we'll offer you protection, but on the other hand, we're also going to increase the fines and the penalties if you breach the law and if you engage in corrupt activity. Similar for the fire services. And then customs. So, Madam President, this piece of legislation, as I said at the outset, captures the prisons, the police, the immigration, fire, and customs. And what it is meant to do, quite simply, is on the one hand, offer them increased levels of protection by increasing fines, and in some instances, introducing new criminal offenses that may be committed in those environments. But on the other hand, increasing the levels of responsibility that we expect out of the various men and women in these services. At this juncture, Madam President, through you and through the Senate, I'd like to use the opportunity to thank the men and women who, on a daily basis, 24/7, under these various services, sometimes in extremely difficult circumstances and environments, continue to do their duties and their jobs to make the life of citizens of Trinidad and Tobago a safer one and a better one. So I thank the prison services, the police, immigration, fire, customs. I use the opportunity to tag on there as well the lifeguards, or defense force, or probation officers. And all I'd like to say, Madam Speaker, in this very short contribution, but an important contribution, I'd like to just tell all of the senators that we look forward to your assistance in the passage of this bill and your contributions towards the effective passage of this bill, and the effects that this bill and the specific offenses and the specific increases in penalties and sentences will have on the men and women in these various services. And to thank you all for continuing to have that conscience to help all of these officers make Trinidad and Tobago a safer one. Thank you very much, Madam President.
Senator Hussain.
Thank
Thank you very much, Madam President, for allowing me the opportunity to contribute to this debate. This miscellaneous provision bill, an act to amend the Criminal Law Act, the Prisons Act, the Police Service Act, the Immigration Act, Fire Service Act, and the Customs Act. All, Madam President, that deals with the increased fines and the creation of offenses for persons involved under these various pieces of legislation who are classified as law enforcement officers. And Madam President, from the bill, it is quite an omnibus bill as it seeks to deal with all of these officers together and tries to create some sort of consistency when it comes to the types of offenses, the sentences that would be imposed for someone who's convicted, and also bringing all of these persons under the same piece of legislation so that when we treat with all of these, the court at the end of the day can really understand and discern what is Parliament's intention when it comes to sentencing. And Madam President, the government gave the impression that this piece of legislation will assist with respect to dealing with some sort of corruption within all of these services, and also to bring some sort of comfort to the citizenry. But Madam President, we all know at the stage in which the criminal justice system works, for sentencing to take place is post-conviction. Because for any person to be sentenced, first you must be found guilty of an offense. And while we may increase all of these offenses, the sentences for them, and also to create new offenses, it is no guarantee that this bill will be effective. It would not be effective unless we deal with the problem of securing a conviction. We must increase our detection rate. We must ensure that the time in which a conviction is, you get a conviction is fast, and you must also ensure that you get a safe and secure conviction. Because, Madam President, at the stage of sentencing, there are several factors in which the court will take into account. And this bill deals directly, and most of it, with sentencing and the creation of maximum offenses. And I think the population must understand what a maximum offense is. Because in this case, the offenses that are being created are what are the highest threshold in which the court can order. And if, for example, let me just look at the first clause in the bill, which is Clause 2. Clause 2 increases the offense for wasteful employment of police time from $1,000 to all the way up to $150,000, a $149,000 increase, and also increase the term of imprisonment for 6 months to 5 years. But, Madam President, this does not mean that if a person is convicted of wasteful employment of police time, that they are going to be automatically fined $150,000 or imprisonment for 5 years. It doesn't mean that. It means that that is the maximum sentence that person can receive. So creating an impression that we are increasing fines is not the end of it. There's a sentencing commission in Trinidad. There's also the judiciary, which is independent, and Parliament must not tell the judiciary how they must sentence, because at the end of the day, that is the discretion of the judicial officer. But, Madam President, I, as a member who practices at the bar, let's just say, hypothetically, I'm representing a client who is charged with wasteful employment of police time, and my client is convicted of that offense. I find it very difficult for a judge to sentence that person to a fine of $150,000 or any term of imprisonment. Because, Madam President, you will appreciate that there are more serious offenses in this country, and persons are not given such a harsh penalty. So I don't see whether or not just raising this fine to this enormous amount will actually be something that a judge or a magistrate may actually sentence a person to. I don't know if my colleague Senator Sobers will agree with that, because there are much more serious offenses that may not warrant such a high fine. So I'm saying that when we create offenses, we must look at other offenses and create that sort of comparison to see whether or not what we are implementing in the Parliament is in line with other more violent and serious offenses. Because it cannot be that an offense for just wasteful employment of police time could probably carry a higher penalty for that of, let's just say, an assault on someone's person. So that is the first point I'd like to make, Madam President. The second point is that this bill is really geared towards deterrence. It is geared towards deterrence because you increase fines and you impose harsh sentences if you want society to behave in a particular manner. Because if these offenses carry these high penalties and high sentences, you would appreciate that someone will be not inclined to committing a crime because they know that, listen, I will be fined this enormous amount and also be in prison for such a long period of time. So it acts as a deterrence. But in order for a deterrent to be effective, you must have two other factors, Madam President. And those two other factors are, one, that you must have the certainty of a conviction, and you must also have the expediency of a conviction. Because that in itself will will comprehensively deter a person. Because once you have detection rate increase, and you have the surety that a person will be convicted, you also have that happening very expeditiously in a few months, and also you have harsh sentences. Persons may not be inclined to committing criminal activities in the country. And that is a problem that we currently have in the criminal justice system, because we have cases that are sitting in the criminal courts for decades in some instances, and there can be no light at the end of the tunnel in those cases. And criminals understand this. They are bright. They conduct an enterprise because they know they commit their crime, but they are not going to be convicted until the next 10 or 20 years in some instances. So we must fix that overhaul in the criminal justice system, Madam President, if we are to increase these fines for there to be some sort of effectiveness with respect to this legislation. I can give one instance, Madam President, and this has been in the public. This deals with the prison break instance, where recently members of the Service Commission appeared before the Joint Select Committee on National Security in a public hearing. And you would have found, Madam President, that in some instances, disciplinary action alone by an administrative tribunal in this country can take years. Can take years, Madam President. So imagine an administrative tribunal where the rigidity of the evidence in terms of admission of those evidence is not as harsh as the criminal courts. Take 3 years. Imagine what happens in the criminal courts where there's rigid objection and very strict rules with respect to the admission and testing of evidence. So all of these things may sound good, but it must be implemented in the reality of the system. And the current reality of the system is that I am sure if somebody is, when this bill is passed and somebody is charged with any one of these offenses, that a conviction is not soon. A conviction isn't coming anytime soon, Madam President. So this bill will take several years before it's probably applied, because you have to first find and get and secure a conviction. And that is an important point that the government needs to take into consideration. Madam President, under the police service, because this bill deals with the police service comprehensively, when you look at the police service, there are 3 ways in which a police officer can, in fact, a police officer, with respect to all of the other officers, has to answer most accountably. And I say this because they are subjected to 1, the criminal courts, 2, the Professional Standards Bureau, and 3, the Police Complaints Authority. The other officers don't have all of this rigidity and layers of layers and manners in which they are to be accountable for their actions. Let me put it that way. But, Madam President, the police service, in terms of their convictions for officers who are errant, I was expecting that the government could have provided some sort of statistics with respect to these manners in which the police service and those officers are convicted. But luckily, Madam President, just last week, all of us as members of the Senate received a package, which was the Police Complaints Authority 2018 Annual Report. And in that report, Madam President, it was very worrying, and I'm looking at page 32 of that report, which gives a statistical report for the period 2017-2018 with respect to the Police Complaints Authority. And, Madam President, that report says that there have been 725 initial reports for the period October 1, 2017 to September 30, 2018. And, Madam President, if that figure is not worrying, especially in our police service, with respect to those high numbers of complaints that are being made, then there's some sort of issue that we must address. And my respectful view is that this bill, while it may be well-intentioned, is not going to address that issue. And they gave a breakdown with respect to the allegations that were made against police officers. The first one is police corruption, and it's 29. No, that's the number of allegations. Serious police misconduct, 389. The commission of a criminal offense by a police officer. The police officer who should be charging persons for committing criminal offenses. There are allegations of 255 complaints made against police officers who committed criminal offenses within 1 year, Madam President. That is some worrying statistics with respect to this matter. And the time in which these matters are disposed of, we don't have any sort of statistics to guide us with respect to that. Now, I'm looking at the types of criminal offenses that these officers will be engaged in. They're engaged in assault, 176, larceny, 58, fraud and corruption, 54. And the reason I'm quoting these two figures, Madam President, is because these are offenses of credibility. And clearly, if we have an issue with respect to credibility within the police service, we have to look at the recruitment exercise and the subculture of the police service. Because if we have to come to this parliament to bring a bill to increase fines to deter our police officers from committing criminal offenses, we have a serious issue. And it goes inconsistent with the government's policy. And let me say this, because this week you have brought a bill to the parliament to say, well, we have a serious problem in the police service with respect to the conduct of officers. But last week, you brought a bill to the parliament that deals with bail for police officers who can in fact frame citizens of this country and deny a person bail for up to 120 days. So it shows some level of inconsistency with respect to the government's approach and policy when they deal with legislation. Because, Madam President, you will well appreciate that there are, in fact, members of the police service who engage in criminal conduct based on the statistics. But I just asked the Attorney General for some guidance, whether or not these offenses and the amendment to the Police Service Act, through you, Madam President, to the Honorable Attorney General, and I could probably give way just to get some clarification, is whether or not these offenses will also apply to special reserve officers, because I know they are governed under a separate act of Parliament.
The SRPs are governed under a separate act, and they would have to be treated with in a different way. The amendments that are going on with respect to them right now involve us trying to work out the process from the Privy Council decisions. So we've kept that apart. There are estate constables as well, So there are a few other categories of people not yet included, but specifically not yet addressed because there's some Privy Council decision retrofitting that's going on.
Thank you very much, Attorney General, for the guidance. And the reason I raise this point, AG, Honorable AG, is because when I looked at the Police Complaints Authority annual report, at page 83 of that report, they also raised the concern because it reads that they made a recommendation that the PCA Act, the Police Complaints Authority Act, also be amended so that special reserve officers can fall under the regulation so that they can also be dealt with under the PCA with issues of serious police misconduct allegations. And according to the Police Manpower Audit Report, Madam President, there are 1,477 full-time SRP officers and 626 part-time officers. So it shows that we have a large complement of officers that would not be captured under this particular legislation before us, Madam President. So that is about, let's just average about 2,000 officers, or 2,200 officers, who will not, police officers, SRPs, who will not be captured under the present legislation. Now, Madam President, when you look at the particular piece of legislation, it goes on to talk about correctional rehabilitation centers. But I heard and I listened to the Minister of National Security, and he spoke about prisons and that it should be a place of, he spoke as though that the prison should be a place of punishment. And yes, it is a place of punishment, Madam President, because it restricts someone's liberty. But the ultimate aim of the prison service is that of rehabilitation. So at the end of the day, Madam President, you cannot just speak of the prison service as though it's just going to incarcerate persons. And you would realize that we have to treat with what is happening in the prison service now, with trafficking, with prohibited articles that are all covered under the bill, because there's no proper rehabilitation at the prison service, Madam President, the prisons. Because the government must also deal with that, because as the Minister of National Security says, that all this Parliament can do is pass laws. But as a minister, what you have to do is do the work. And you have to implement your policies and distribute your resources in such a manner that we don't have to come to this Parliament to pass this sort of legislation in order to deal with these things. But quite interestingly, while reading the bill, I saw that the Attorney General included in the bill the list of prohibited articles, and it's an exhaustive list with respect to paragraph A, and I appreciate that the Attorney General also kept prohibited articles under the prison rules, because that way you can include other items as you go along. But, Madam President, when you see the list of prohibited items, I was very concerned when I was reading that there were included letters, papers, and books. But then I saw the caveat at the bottom, which says that it must be prejudicial to the safety, security, and good order and discipline of the prison. So I was satisfied when I saw that part of it. But it also includes something very interesting, which is mobile telephones, cameras, recording devices. Now, Madam President, and I expect the Attorney General to address this issue in the winding up of his presentation. That issue deals with the prison jammers. I don't know what is happening with the prison jammers at the prisons, because, yeah, the phone jammers. Because quite recently and very frequently, you see lots of videos being filmed from the prison service. And there's a range of things that happen inside there. You see sometimes fights, you see men smoking, they're just singing and liming in the prison and then sending these things out on Facebook, on social media. And it is quite worrying, Madam President, because some persons in Trinidad, outside of the prison system, right here in Trinidad and Tobago, cannot afford to have data on their cell phones. Whereas you have prisoners in our prisons filming videos courageously, showing their faces, and then publishing it on social media. That in itself is how blatant and arrogant these persons are. that they know that they can do these things without any sort of serious repercussions. And that should not be where Trinidad and Tobago should be, Madam President. It is just mind-boggling to see some of these craziness that happens in the prison service. Because when you look, I was doing a little research on the prison jammers, and I happened to come across a Joint Select Committee report on human rights, the Human Rights Committee, where an investigation or inquiry was done with respect to the prisons. And this was the 5th report of the 3rd session of the 11th Parliament. And it dealt with the operation of the cell jammers at the remand prison, the women, and the MSP, the maximum security prison. And in 2017, Madam President, the report indicated that these jammers were operational. But if these jammers are operational, I can't understand why these videos find themselves on social media, because they can only come out of the prison service. And those, if we have all of these things in place and they are operating properly, you can actually cut the criminal out, Madam President, of they sending certain messages and directions from inside of the prison wall, because that is real. Because there are crimes in this country that will take place because of instructions and directions given inside of the prison service. I look at the amendment to Section 8B of the Prison Service Act, Madam President, and I saw that it included images and sound recording. I don't know whether or not that would have, if video recording will also be covered in 8B, because it spoke directly of image. And when I look at the definition of what image is, a photograph, it spoke of, photograph is defined as, it means a recording on any medium on which an image is produced or from which an image may by any means be produced. So I restricted document. I don't know if, yeah, that's the definition of, that's the definition found at page 9 of the Bill AG. I'm seeing photograph. I thought it would have been whether or not we should specify video, because I know we are dealing with a particular piece of legislation, and we have found a formula that would have defined video. But I don't want to go into the details of that as it's before a committee. So we probably could look at that definition of video. Now, Madam President, I'm moving on again to clause, the amendment to the Police Service Act with respect to clause 50, capital G. And that is found at page 15 of the bill, Madam President. And this deals with a person who refuses to give his measurement or take a photograph or fingerprint when he's in the custody of the police. And the fine in that case, in that instance, is increased from $10,000 to $50,000 and imprisonment from 2 years to 3 years. Now, Madam President, that deals with a person taking, the police taking the person's measurement, taking their photograph, and 3, their fingerprint. So I married that and I looked at the DNA legislation, the DNA Act. And the offense for the DNA Act, if a person refuses to give an intimate sample, the maximum sentence there is $10,000 and 2 years imprisonment. So the bottom line is that if a person refuses to give a DNA sample, the sentence for it is actually less than if you refuse to give a fingerprint, a measurement, or a photograph, Madam President. So I think we should have some level of consistency with regards to those requirements that police officers have to comply with when a person is in custody and being processed for the court. And, you know, this is a little segue, Madam President, that I can't understand why someone who is in custody will refuse to give a fingerprint, because at the end of the day, it's beneficial for them to give a fingerprint. Because when you come to court, Madam President, and you make an application for bail, the police will say, well, listen, we have no tracing on this person because they refused to give a fingerprint. So I can't understand why someone will refuse to give their fingerprint in the police station, because it's actually beneficial to them in order to secure bail in a quick manner. That is one of the other issues I would like to raise with respect to that. Now, I know there is a lot that has been said about lawyers, and I wouldn't repeat the words that the Prime Minister would have described lawyers in this country. But I would just like to say, Madam President, that I am totally, I want to put it on the public record, that I do not support the view of the Prime Minister, and I condemn it to the highest degree. While there's an issue, and there may be issues with respect to attorneys, you cannot label them like that, Madam President. It's inappropriate and disrespectful to the legal profession to label attorneys in that manner, Madam President. And I say this because this directly deals with clauses in the bill in terms of the tipping off offenses and the protection of legal professional privilege. And I'm glad that there's a defense with respect to that particular offense when it comes to legal professional privilege. So that and I totally agree with it, that if an attorney at law is engaged or furthering any criminal enterprise, you should face the courts. You should be arrested and charged if you are furthering a criminal enterprise. But you don't go on a public platform, on a political platform, and cast all attorneys as some other word that is not even parliamentary, that I can't repeat in this House, Madam President. I cannot repeat it in this House. The other offense and the new offense that is being created is with respect to the trafficking offense. The trafficking offense, Madam President, there are a series of actions that will constitute trafficking. And I saw, I'm looking at the prison, all of the trafficking offenses are very similar. And I see that there is a caveat with respect to that. It deals with pecuniary interests and business enterprise. So that prison officers, it deals with the issue that prison officers sell items to prisoners. And I remember I had a client, and I'm not prejudicing anyone, but he indicated that a cigarette sells in the prison, one cigarette for $100. $100. So you could imagine what a cell phone or a phone call may go at, Madam President. And you also have to also imagine where the criminal and the prisoners are getting this money to pay for these items. And these transactions, yes, must be clearly dealt with. But I agree that we should create that fine for trafficking. But what about detection, Madam President? The best way and the best evidence and the best deterrence for this to stop is to ensure that we have proper CCTV cameras working in the prisons, so that you can track and you can see whether or not the prison officers, and it's easy to detect and convict based on the CCTV evidence in the prison. And that is an issue that we have to deal with seriously. But I know, Honorable Attorney General, I also would like, if you can touch on this in the winding up, is that I saw in the last clause that deals with respect to trafficking, is that you speak of any benefit whatsoever. Now, retaliatory action is a separate offense, and this is where I'm going with this, is that if someone who's a prison officer is threatened that I need a phone call, otherwise I will kill you, I'll kill your family or whatever, whether or not that, and they carry the cell phone, whether or not that will be a defense for that person. Yes, the prisoner will be charged for that retaliatory action. Now, I know there will be the defense of duress and all of those other common law defenses, but Madam President, in this particular instance, whether or not, just like how we have the exception to the legal professional privilege, I know prison officers will want to use it to their benefit and say, well, listen, all of them threatened to kill me or my family, so I'm going to give them the call. Two issues. One, whether or not, if they do it, they'll be captured under this if they have been threatened by any sort of prison officer. The second issue is whether or not we create some sort of exception or some sort of mechanism to deal with those instances, because those are where it comes. Because you will have the prison officers, you see them on TV very often having press conferences with respect to the threats on their lives, and that they are forced to do certain things with respect to the criminal element that are in the prison system. Now, Madam President, I want to end before we go for tea. So I'm going to conclude my presentation, if you will give me the extra 2 minutes, if I can. And Madam President, I just want to say, I just want to say, Madam President, that the Attorney General started off, he started off his contribution with the blame Kamala syndrome. But I thought by now that may have concluded after Monday's results, Madam President. And then I heard that the Minister of National Security was congratulating our bright Senator Sobers. So I thought that the licks got them a little buzzery, Madam President. So, Madam President, as I conclude my presentation on this bill, Madam President, I just want to say that we have some issues that we will deal with at committee stage. And thank you very much for giving me this opportunity. Thank you.
Honourable Senators, we will suspend the sitting and we will return at 2 minutes past 5.